Great. Well, ladies, gentlemen, thank you so much for taking time over your evening to join with us this evening for tonight's webinar. The reason why we wanted to host this webinar, why we wanted to put this webinar on, is that some of you may or may not know about the recent changes to the New South Wales, or sorry, a recent bill that was introduced called the New South Wales Equality Legislation Amendment Act, I believe, or the Equality Bill for short. A lot of good changes and outcomes from this new bill. And one significant change was the some of the reforms that they've introduced now for intended parents who've engaged in international surrogacy. I believe it's one of the first times it enables the bill for the issuance of parentage orders for children born through international commercial surrogacy, so long as certain criteria are met and obviously in the best interest of the child, which our guest speaker tonight is going to talk about in a little bit more detail. So for those of you who don't know who my guest is that's joining today, Sarah Bevan is a very, very well-known lawyer in New South Wales and in Australia. I think she's almost 20 years in the industry, maybe more. She can probably correct me on that one. But a lot of experience in this landscape, trusted advisor, a lot of intended parents, whether they do surrogacy domestically, internationally, seek out her services and seek out her advice. So we're very, very lucky to have her here this evening to share with us her knowledge and some updates about this bill. I'm going to jump to her in just a moment to let her introduce herself and kind of get started. But from a housekeeping point of view, there will be a Q&A button somewhere on your screen. So if you do have any questions throughout this evening, you're more than welcome to put that into the chat. And we'll either get to it at the end or throughout the evening. Other than that, Sarah, the floor is yours.
Thanks, Stephen. Okay, so as Stephen said, I was basically trying to say that I'm old and I've been around a long time. I guess that's true. I'm a lawyer practicing in Sydney, but I practice throughout Australia, and of course, most of my intended parents are people who are going overseas for obvious reasons. So, the Equality Bill in New South Wales, it's a really big and exciting piece of legislation, not just for law nerds like me, but because it provides a potential pathway to parentage, to legal parentage, that hasn't existed for the vast majority of parents through surrogacy in Australia, that is, parents who go overseas. So to understand it, I guess we first start at the beginning. So what is the law we're looking at? Surrogacy in Australia is state-based primarily. There are a few exceptions to that, but state-based primarily, so state by state. And the law that applies to you is the law it's the law in the state where the intended parents live. The law we're talking about now only applies to New South Wales residents. And one of the things I'll be talking about is, what does that actually mean? We'll get to that. But the Surrogacy Act, or all surrogacy law in Australia is based on legislation. In New South Wales, it's called, creatively, the Surrogacy Act. And there are two main parts for your purposes that are relevant in the Surrogacy Act. Firstly is stage one, so the agreement stage. We're not really going to be looking at that today. It is relevant to the practical side of what you might be doing next. But for today, we're going to be looking at stage two, which is the parentage order side. Now, in making a parentage order, or in considering, when the court comes to consider whether it will make a parentage order, it has a whole lot of requirements. One of the probably most known requirements is that the child at the time of the application is between 28 days and 6 months old. And probably a lot of you online have children older than that. So what does that mean for you? We are going to get to that. Doesn't mean it's out of the question for you. We're coming back to that. There's then a section that sets out preconditions, and there's mandatory and non-mandatory, which of course, if it's mandatory, there's no way around it. You have to have complied with it. If it's non-mandatory, then you should be complying with it and you aim to comply with it. But especially for retrospectively trying to get parentage orders, you probably haven't complied with it. So your surrogate probably hasn't had Australian legal advice. She probably hasn't had counselling with an Australian Australian Registered Counsellor. So all of those are some of the non-mandatory preconditions, and we'll look at how that works. So some of the mandatory preconditions that you can't get around are things like the age. So you all have to be over 18, and for the surrogate, generally over 25. You have to have an agreement in place pre-conception. So you can't go, oops, we're pregnant now, we'll do it. And the one that always makes me chuckle is you can't be a throuple. You have to be a single or a couple. I always wonder about why that was needed to go in there. Anyway, so if you don't meet a non-mandatory precondition, the court has discretion to still make the parenting order if exceptional circumstances exist. Now, from a legal standpoint, exceptional circumstances is a fairly high test. But from my other part of my law that I practice in, which is general family law, exceptional circumstances applies for setting aside things like prenup agreements. And in that case, the bar is really high. So, of course, I look at exceptional circumstances and get worried about how high the bar is going to be. But the case law in surrogacy actually has a somewhat circular argument about best interest in exceptional circumstances, so it's not as high as it might otherwise be. And it's at this point about the exceptional circumstances where the change comes in. So what's the change? I'll tell you what it's not. It's not that you can now automatically get parentage orders if you go overseas and engage in commercial surrogacy. If that's the messaging that's out there, that's not accurate. It provides a potential pathway. So it's not guaranteed at all. The law isn't in effect yet. It's going to come into effect at the latest on the 1st of July next year, but hopefully it'll come in a bit earlier on what we call proclamation date. So if it gets proclaimed earlier than that. But at the latest, 1st of July 25. You can only make the application, an application for a parentage order after the law comes into effect. So it's great you're all here now thinking about what do I need to do? How do I get ready? That's great, but you can't actually do anything right now. What it's also not doing in the new law, it's not allowing commercial surrogacy per se. So that criminal offence that exists for engaging in commercial surrogacy anywhere in the world remains. As everyone probably knows, no one's ever been prosecuted for it, but it still remains a criminal offence. Hopefully that will change. There are reviews happening in government. Hopefully that will change at some time. So what the law does is it says if you have engaged in commercial surrogacy outside of Australia, then there is a potential for the court to still make a parentage order for your child if exceptional circumstances exist, if you have not met all of the non-mandatory preconditions. There's an exception that if your child is under 6 months at the time that you're making the application, so if you're pregnant now, then this might apply to you by the time the law comes in, then you're looking at a best interest test. The difference is probably not as big as it might otherwise have been. But generally, the court is now going to be able to look at commercial overseas parentage, overseas commercial surrogacy arrangements and potentially make parentage orders on the basis that it finds in exceptional circumstances to do so. Another part of the change in the law is that one particular section says that the altruistic requirement for a surrogacy arrangement is no longer a mandatory precondition for international arrangements. It remains mandatory for domestic, but it's no longer mandatory for international. So you might be thinking, why is this important for those of you who have had, you've got your child your child's been born and everything. You've got your citizenship by descent. You're back in Australia. You've got your Medicare card for those with older children. He or she might be enrolled in school, and you've been able to do all of that. On a day-to-day basis, that is what happens. Most people are able to go about their lives, especially in circumstances where both parents, if you're a couple, or one of you, single, is on the birth certificate for your child. So if you're a gay male couple, obviously when you produce your birth certificate, people know that you didn't give birth to the child, so somehow you've had your child in some arrangement, but there's no questions asked. You are the parents as far as everyone else is concerned. The difficulty is that technically, under Australian law, you're not a parent legally. The reason being is section. It's late and I'm slurring my words, and I haven't been drinking. I will after though. Is Section 60HB of the Family Law Act. And what that says, it circles back to state law to say you are only a parent legally through if your child is born through surrogacy, if you have a state-based parentage order. So there's that circular argument. And a lot of Australian law to do with succession, superannuation, all of those sorts of things rely on the Family Law Act for the definition of parent. So those acts refer back to the Family Law Act for defining what a parent means. So technically, you're not a parent. Where it might come up is some of the tricky legal things, or the tricky and unusual things that might come up. So one great example that I had never even thought of until I was asked at the inquiry last year was if your child is trans and is going for gender affirming treatment and your child is still a minor, for the parts that parents can authorise, technically, potentially, the hospital could say, well, you're not parents, so you can't actually authorise this. Another example is wills and succession. So if your parent leaves their estate to their grandchildren, which means the children of their children, then technically your children might not be or won't technically qualify as children. So if you've got a greedy sibling who wants to grab the inheritance for his or her children, then you'd have some difficulty. And the other reason why it might be important is probably the more obvious one, which is identity. So most children aren't going to be aware of these legal definitions, but think about how much information they have available to them on the internet, and they could start asking questions. And a lot of the children born through surrogacy in Thailand, India, when it started getting more common in Australia, and now at that sort of preteen, early teenage years, where it can be really where issues of identity might be coming up. So that's another reason why this might be important. And probably the most common occasion when it's going to be important is if you're a couple, only one of you is on the birth certificate. So if you are in a circumstance where wherever you went to, only one of you, that is the biological parent, the one with the biological relationship to the child, is on the birth certificate and not the other person, then you've already got those problems that have arisen because the other parent, who is equally a parent in day-to-day life as the biologically related one, might not be able to get that same recognition at school, at hospitals, things like that. So that's probably the most common situation that's going to arise. Okay, I've got to say, any questions you have along the way, feel free to ask. I don't mind being butted into at all. I have 3 children, so I'm perfectly used to, never being able to get a sentence out. Same with you, Stephen. If you've got any questions, go for it. Okay.
I do have one. Did you want to keep going or do you want me to jump in?
You can jump in if you want.
Sure. It's something that you said, I think, very, very early on. I'm not sure if it was a mandatory requirement or a non-mandatory requirement, but you mentioned that the surrogate needs to be over the age of 25. Is that a hard and fast rule? What happens if an intended parent that's on their surrogacy journey has a surrogate that's below the age of 25?
So being over 18 is mandatory. Being over 25 is a non-mandatory requirement. So she's expected to be 25. Parents can be 18, but she's expected to be 25. But if she's between 18 and 25, that's a non-mandatory provision with some extra requirements.
And okay, thank you. You've mentioned also the difference or potentially that fine line between commercial versus altruistic. A lot of our intended parents that may be on the webinar tonight have chosen a variety of programs. You've got the USA, which is a very clearly commercial framework, but then you've got situations like Colombia, where in the eyes of the Colombia program it is an altruistic nature. But I think you might suggest that it's not an altruistic program in the eyes of potentially the courts.
Yeah, so that's exactly where I was getting to. So yes, so a lot of countries, Canada, Colombia, even Argentina, present themselves as altruistic, and under their law, they are altruistic. I assume I'm not an expert on their law, but one can assume that if they're putting themselves out there as altruistic under their law, that is how they are. Our law doesn't actually provide a specific definition of what an altruistic surrogacy agreement covers in terms of expenses, but it gives examples. And the blanket payments or the bulk payments that are made to surrogates in those countries that are altruistic under their law doesn't qualify, arguably, for being altruistic under our law. So Canada, for example, although a lot of people choose Canada or Colombia because of the altruistic model and because of the risk of the criminal offence, in this case, you actually want it to be a commercial arrangement because part of the I think holes in the drafting in this new law is that it refers solely to overseas commercial surrogacy. It doesn't refer to overseas altruistic surrogacy. I think that's an oversight. These changes, the whole process of the Equality Bill, it went through lots of different changes. And at one point, I was asked to look at a draft of a new law that was really quite something different. And then all of a sudden, this came out. And there's not a lot of understanding of how surrogacy works and surrogacy law works. So I do think it's a bit of an oversight, but you do have to be a commercial. You have to have engaged in commercial surrogacy to avail yourself of this, which seems a little bit silly, but that's the way it is. So in theory, if it's genuinely altruistic, then you're going to you can't rely on the new law. You would simply be relying on the old law and trying to get it through that way and relying on the old provisions of exceptional circumstances if you haven't complied with non-mandatory preconditions. Okay, a couple of other issues to cover. When can you do this? Now, I said earlier that the law refers to the child being between 28 days and 6 months old. That's the standard requirement. That's not a precondition. That's just one of the requirements. However, there is provision for the court to still make orders in exceptional circumstances. So either way, if your child is older than that, so you did surrogacy 5, 10, whatever years ago, and now you're going for a parentage order, you're going to have to satisfy the exceptional circumstances test because your child is over the 6 months limit. You can do it at any time until your child's 18. The one issue is that if your child is old enough to express wishes, they would have to do so at the independent counsel's report stage, which is mandatory anyway. I shouldn't use the word mandatory because it's not a precondition, it's just a requirement. You still need to get an independent counsel's report. And so, if your teenager is being difficult, doesn't like you because, that's their job as a teenager, um, you've got to find a way to make it work. So they do say that they want to legally be your child. Um, I think I've given my 13-year-old an option. He would probably say no at the moment. Little darling. Um, okay, so getting back to the issue of New South Wales residents, I've been asked various questions like, we were in New South Wales when we entered into the surrogacy arrangement, but now we live in whatever other state. Can we do it? The answer is no. The requirement is that you are living, you're resident of New South Wales at the time of the hearing. So when you make your application. Um, I guess one of the concerns I have is that some people who are really, really keen for this might be moving to New South Wales to make it look like they're resident in New South Wales to avail themselves of these provisions. Entirely understandable. Resident means, it has the ordinary word. So it basically means, are you habitually resident in New South Wales? I can't answer that. I answer that by way of example rather than giving you an actual definition. I just lost my train of thought there. Now, one of the biggest things, most important things that I want to talk about is one of the mandatory preconditions, which is the consent of your surrogate. Now, if your surrogate, if you haven't matched yet, you're about to go through this process, then great. You really need to be getting your documents prepared in advance. That's great. If your surrogate is pregnant now, it's too late to have them added. It's too late to do your written agreement prior, but we can still fix up things. If your baby is, if you have a very young child and you are still in contact with your surrogate, great. If your child is older and you've had no contact with your surrogate for however many years, then you've got the issue of how are you going to get consent from her. There is an exception in the legislation, so in the Surrogacy Act, that says you don't have to have the consent of the surrogate if you've made reasonable endeavours to find her and you haven't been able to. Now, it's a really, really big issue, this consent one, because you all know that she's consented. Obviously, she handed over the child, and she's been out of your child's life, by the arrangement that you have entered into, and she's totally fine with it. And she might have seen a counsellor, or she might have told your agency staff, I'm so happy that I've done this, and I'm happy that the baby is off with his or her parents, and everything's great, and I'm really happy with how everything's worked out. That's all not admissible and not part of our evidentiary requirements. So we have requirements under the Evidence Act, so rules of evidence, basically. Her consent has to be given basically in the form of an affidavit. So if you find her, so if you go out of your way and find her and she is just not interested and she's like, no, I don't want to be signing anything. I don't, it was however many years ago, I've moved on, I can't be bothered. If she says that, then you've got no way around it. You've got some real problems. If you can't find her and you've made reasonable efforts, then you can rely on the exception in the legislation. So if you fall into this category where you haven't had contact with your surrogate for a while, one of the most important things that I want you to take away from today is get advice before you go looking for her, because there could be real problems. So that's one of the biggest takeaways. Please get advice if you're not in contact with your surrogate. Get advice before you go looking for her.
Could you, let's say we've got a mixture of intended parents that may be very close with the surrogates, other that may not be. Do you think one approach or the other would see a better success in the eyes of the court? So let's say, for argument's sake, for intended parents that might be fairly, friendly with their surrogates and they can get that letter. Is that approach going to be a more successful than those that don't provide that letter?
It means you've got one more of the non-mandatory, one more of the preconditions ticked off. So the more preconditions you're trying to get exemptions through, the harder it might be. So absolutely, if you're in contact with your surrogate and she will sign this affidavit, then that's great. That's far preferable to having to rely on an exception that you can't find her, because most people are going to be relying on quite a few non-mandatory precondition exceptions. So, Australian legal advice. Most people, I can't remember any clients who have had their surrogate get Australian legal advice before they enter into the thing. So that's one. Another one is Australian counselling. I can't remember any clients who've had their surrogate get Australian counselling preconception. So that's another non-mandatory that you're going to be asking for an exception from. When you start adding them up and then you add on the lack of consent as well, it's just another thing to add on. It doesn't mean you're not going to get it, but basically the better you can present your case, or the more that you can satisfy the court, the easier it might be.
And what about that actual document that, let's say, you reach out to your surrogate? How does it need to be presented? Is it something that she can type up, email? What level of affidavit does it need to satisfy under the eyes of the law?
It should be on the Supreme Court affidavit form, and if she's overseas, she would have to get it signed appropriately, which is generally with a notary. Doesn't need to be apostilled, but generally would need to be signed with a notary or an Australian lawyer, a registered Australian lawyer who's based overseas. And in theory as well, in theory, New South Wales, so during COVID, we introduced electronic witnessing provisions. So in theory, but there are some problems with this, in theory, the Australian lawyer could witness her signing it over Zoom.
Okay. And then what about for those surrogates that English is not their first language? Would the requirement be that she signs it in her own natural language as well as an English version? Does it need to be an authorized translation? Where would they be sitting in that area?
So the way we do affidavits in Australia with non-English speakers is we have what's called a jurat. It's the signing part at the back of the affidavit, which is a translator who says, I have read this to her in, let's say Spanish, and she has understood and signed it. So there's an extra requirement of the jurat. What I am going to be advising people to do is to have two copies, so the English and the first language. I think we've seen the embassies wanting to see documents in the surrogate's first language as well, and having some issues where it's only in English. So I think that's the preferable way to proceed, is to have it in two, and to have that translator attest to that second version, whatever other language it is, Spanish say, attest to that is a direct translation of the English version at the front.
Great, thank you. There's a couple other questions coming through.
Yep.
Did you want to carry on with some other information? I'll come back to it. Okay.
No.
One of our questions was, in the event that maybe an intended parent has not yet maybe met their surrogate, maybe they haven't matched with, maybe they're quite early on their journey, do you recommend that she signs the New South Wales affidavit beforehand, or wait till afterwards?
So if you're not yet pregnant, then that's where you would start doing things in accordance with the New South Wales provisions. So that is getting a New South Wales surrogacy agreement, which you both sign, Her affidavit that I was talking about can't be signed until the baby's born. So basically, she's saying, I gave birth to this baby and I consent for this baby to be the legal parents of the intended parents. Affidavit can't be done until after she's given birth. But if you are pregnant, or not pregnant, sorry, if you are early in your journey and not yet pregnant, start basically talk to me sooner rather than later so you can get everything done in advance and you can comply with all of those requirements and you're not going to need to rely on the exceptional circumstance test in order to get your parentage order.
Do you see value in, like I said, if we've got quite a few intended parents that might be in the same boat, is there some way that we can maybe streamline and have, many intended parents come and we get maybe a standardized document and then that can be, sent out to their surrogates when they are matched with them?
Yeah, so couple parts, few ways I'll answer that question. The surrogacy, so generally, if you're going through a domestic arrangement, the surrogacy agreement, or we technically it's not an arrangement, the surrogacy agreement, so the contract basically that you write up can have pretty much anything and everything you want into it. And I advise my domestic clients often more is more. In most areas of law, I say less is more, but in surrogacy agreements, I say more is more. For people who are going to be using this as an adjunct to what they're also doing over in wherever, Colombia or wherever, then it might actually be the opposite. We'll do the absolute bare bones of the surrogacy agreement so that it just covers the absolute basics of what it needs to. She needs to have Australian legal advice on that. So that's one of the requirements. In order for it to be binding, or one of the non-mandatory preconditions is for her to get Australian legal advice on it. So yes, that can be streamlined. The most important part of streamlining is the second stage, the parentage orders, is that I am currently trying to see what the court can do. So I'm in discussions with the court to see if we can do something to make it a very streamlined process. It's a win-win for everyone. It's a win for the court because it might have potentially hundreds of people wanting these orders, and the court only deals with less than 100 a year. So you could imagine them being faced with it and going, I need a holiday. But and also, if we can do it as some sort of bulk application, think it's definitely not a class action, but think of it on the same sort of thing where everyone's seeking the same thing, then the costs will probably be, from a legal fees perspective, depending on how the court wants it arranged, might be around half of what it would otherwise cost, which is going to be a win-win for everyone. Win for the court, win for parents who are going to have a lot lower fees than otherwise. So yes, we're trying to streamline things. Yes. Is the answer to that.
When you said that the recommendation is for the surrogate to receive Australian legal advice, if an intended parent has their own contact or their own Australian lawyer, let's say they're using you, for example, can that surrogate then get the Australian advice from you as well, or does there need to be a separation there?
No, it needs to be a separation. So if we are doing it as a sort of bulk type thing, then it may well be that a few surrogates are seeing the same other lawyer who, I have been talking to a couple of lawyers to basically say, look, if we're going to be doing this to make it as quick and easy for people, we're going to need to look at not charging the same fees because we're going to be doing it one after the other, or potentially together. So yeah, we're definitely in talks about that. And obviously she would need to arrange, or IPs would need to arrange an interpreter for her if English is not her first language. And of course it's going to be by Zoom or Teams or whatever, which is totally fine.
One intended parent asks, does the new law apply to New Zealand citizens or permanent residents living in New South Wales?
Absolutely. You don't have to be an Australian citizen. You don't have to be an Australian permanent resident. You have to be resident in Australia, in New South Wales.
For those intended parents that, because we've got a mix of programs, there's the
Yep,
USA. The outcome of the USA is that they get a parentage order, obviously that's recognized in the United States, has both their names on it. In
yep,
Colombia, they get an initial birth certificate, which will have their name and the surrogate's name. Uh,
yep,
as it currently stands, that's what the expectation will be in Argentina as well, the intended parent's name or one of the intended parents' name with the surrogate. The
yep,
second of the process in our Latin American countries with Colombia and Argentina is having the surrogate's name removed. In Colombia,
yep.
that will be the final birth certificate with just one of their names on. In Argentina, the hopes is that the second parent will be able to add it on. So you've kind of got a bit of a mixture of outcomes when it comes to birth certificates. When it comes to the the submission of the application, does the intended parent need to wait for that second birth certificate from Colombia or Argentina to come through? Can they start what they've gotten from the first one, or is it not relevant?
They can use the first one.
Okay,
So no,
great.
you shouldn't need to wait for the second birth certificate. So just going back to the American one, for example, where you have an order from whatever state in the USA that is a parentage order that's recognised in the USA. Unfortunately, same thing applies. It still doesn't make you legally the parents in Australia because of Section 60HB of the Family Law Act. It needs to be a parentage order in a in an Australian state or territory.
One of the intended parents ask, is it possible, and I'm sure it's maybe written in the Act somewhere, but would it be possible to maybe collaborate this information into maybe things that they need to know, like if they're pre-birth or they're post-birth, maybe with some things or steps that they need to do from a mandatory view or a non-mandatory view to kind of give it a very step-by-step process?
Yep, I'll answer that in a moment. But one of the things that I didn't cover that just sort of prompted me to cover is that one of the concerns I have going forward is that if so, going through the process in order to be able to get a parentage order in New South Wales involves extra steps. And one of the concerns I have, especially for places like Canada, where surrogates have a vast choice of IPs to choose from, is that it may well put them off picking New South Wales residents if they know they're going to have to do these extra steps. So I'm a little bit concerned how that's going to work down the track. But I mean, it is what it is. And I guess we just have to keep our eyes open. So steps. If you are not yet pregnant, then you need to be getting your surrogacy agreement drawn up. You need to both be getting Australian legal advice. You need to be getting your preconception counselling with an Australian properly registered counsellor and drawing up your agreement that way. So they're the sort of basic steps. And yes, legal advice is one of the preconditions, non-mandatory, but one of the preconditions. So you talk to me or someone else if you want to, and get that agreement drawn up. But you would want it to be tying into your other agency agreement and your contract with your surrogate that you have wherever you are. So it's a little bit different from how we usually do things in New South Wales. If you are pregnant right now, then it's too late for the surrogacy agreement. It's too late for the preconception counselling, and it's too late for the Australian legal advice. However, if you are pregnant, you'd be talking to your surrogate about whether she will sign an affidavit and join with you by signing that affidavit, and also get an independent counselor's report once the baby is born, plus relinquishment counselling. So pregnant means independent counselor's report, relinquishment counselling, and an affidavit. All of that can obviously be done online for her. If your baby is born, then before you do anything, unless you are in contact with your surrogate and she says, yes, I'm happy to sign, before you do anything, get advice.
There's a couple of questions from intended parents around Tammuz facilitating parts of these process. So for those intended parents, we can take that chat off online, but to answer generally, it's up to each intended parent to engage their separate legal counsel when it comes to their own Australian citizenship, and parentage. That being said, this is something that we'll try and support as many intended parents through. So if you have any questions and we can streamline things from a Tammuz point of view, absolutely we can assist. But it will be up to each intended parent to engage their own separate legal counsel around that. I'm in the same boat as a lot of you are. I currently do have two children, and we may be thinking about more in the future. So we will definitely be going through these processes and support as many of you as we can.
And to help, what I can do, Stephen, is prepare that little checklist that you can
Great.
have somewhere that will be helpful.
Great. One question is around, is there a difference maybe in fees if they're doing like a USA program versus a Colombia program for your point of view?
No. So in terms of how fees work, for my domestic clients, we charge a fixed fee. So for anyone who's ever engaged lawyers, you know that for most things we charge on a timed basis because how long the thing's going to take. For our surrogacy, we charge fixed fee for domestic surrogacy. Obviously, this is a hybrid, and what I'm also looking at is trying to find a way, like I said before, about working with the court as to how they might be able to do these bulk applications, which will bring fees down substantially. The aim is for half, but it depends on how they're going to require the submissions that I need to write, various things that, part of the legal process. But the aim is to make it about half. Whether it's different for America or Colombia or whatever, is basically no, it's not going to be particularly different because you're still going to have the similar sorts of non-mandatories that you haven't met. But it may well be that one of the things the court wants to do is group the bulk applications by country. I don't know. So that's one of my thinkings. It might be, all the Americans together or the Colombians together. It's something we'll have to wait and see. It's all still very early stages of this at the moment.
Okay. What about from a timeline point of view? Let's say some intended parents, maybe you're on that cusp. Maybe they have just matched with a surrogate, or they're just about to be matched with a surrogate, or they're just about to go through an embryo transfer. So they're kind of that weird window where they're not sure how long all of these steps you've mentioned might take to potentially implement. Do you have a timeline? Let's say we've got one intended parent that might have an embryo transfer in 4 weeks versus one that might have it in 8 weeks. Do you recommend that they start any of these processes now? Will they be able to get everything they need to get done within, let's say, a 4-week period of time? Or do you suggest that in those scenarios, they're better off just waiting until they become pregnant and then follow up with the affidavit?
No, one of the preconditions, a number of them relate to preconception. So if you can get it done before conception, then absolutely try. 4 weeks is always doable. I don't know, for some reason people forget about lawyers and don't think about us. I mean, I'm offended, but so much else apparently better is being done, making babies, but sometimes people leave coming to see the lawyers until it's too late. And we understand about cycles and timing, etc. So we try and we do our best to make sure it works. And if you've got a transfer planned for 3 weeks' time, which would basically be Christmas, but anyway, then we'd try and make it work. And with the partners we work with, we reckon we could do it. But hopefully it's not 2 or 3 weeks. But if it is, contact me straight away. Not in a week.
And would you assist them in obtaining the independent legal advice for their surrogate? As in, could you put them in touch with a different lawyer that could meet that? Okay, great.
Yeah, I'm working with a couple of lawyers to try and make sure it's all streamlined.
Okay, great.
Who understand as well, because it's new. Yeah.
There's one question that they've mentioned. We talked before about the first birth certificate versus the second birth certificate. You said that they can start with the first birth certificate. However, the comment is around that if the second birth certificate has both of their names on it as opposed to the first one, but am I correct in understanding that it doesn't matter because a parentage order doesn't matter what's on that birth certificate? You get to choose those two parents that can be on the parentage order. Is that
Yeah,
correct?
there's the two parents who entered into the arrangement. So, what's your husband's name, Stephen?
Tim.
I think I've met him, but Tim. So your agreement says Stephen and Tim. Um, so regardless of whether it's Stephen or Tim or both of you on a birth certificate, on the application for a parentage order, it's going to say Stephen and Tim.
Is it a let's say I started the journey as a single parent and I met somebody halfway through, so their name's not on the initial maybe contract or the initial agreement, can they still be part of the parentage order in the future?
Generally not part of the parentage order. There are other options, but as part of the parentage order itself, generally no.
And
And
the actual, sorry,
obviously, if you
finish.
were together and you are no longer, so you did it as Stephen and Tim and now it's just Stephen, that's possible.
Okay. That's good to know. Um, is the actual parentage order itself like a brand new birth certificate that gets issued, or is it just a
Yep,
document that says, oh, so it's actually like an Australian birth certificate that they'll see? Okay.
yep.
Um, for IPs or for intended parents who live outside of New South Wales, should they still be putting in all the effort? Oh, okay. So for any intended parents outside of New South Wales currently, do you advise that they still do all the necessary steps if either A, maybe other states might adopt these procedures in the future, or if they were to potentially change states?
If moving to New South Wales is on the cards, so after your child is born, when you're making this application, um, then yes, go ahead and do this. Um, Absolutely. There are similar sorts of provisions, by the way, in the ACT. They're a bit different, but there's ACT actually came first in July, I think. Um, so yeah, if you are potentially going to be moving to New South Wales and knowing that getting this parentage order really is the gold standard. For anyone who's seen the presentations I do, and I have my little gold star and my silver star and then my bronze star, this is absolutely getting a parentage order is absolutely the gold star. So that's what you want. So if moving to the cards, if moving to New South Wales is on the cards, then absolutely go ahead and do it.
I think there's just one more that's kind of come through earlier, but I didn't really understand the context, so I'll read it out loud. So maybe the person that answered it can maybe ask again. It just mentioned we are not able to draft our own surrogacy agreements, though. I'm thinking that maybe in terms of when you mentioned that the intended parents will obviously enter into an agreement with Tammuz separately. They'll also have their
Yep.
own separate surrogate agreement that they enter into in the country that they've
Surrogate. Yep.
chosen. And then now there'll also be a separate Australian surrogate agreement, a standardized one that can be created here. Is that correct?
Yes. Yep. Absolutely.
Great. Let me just double check if there's any other questions that have come through. That's pretty much it that I can see. Yes, the attendee said yes, that was the question. Great. Look, ladies and gentlemen, thank you so much for your time tonight. Sarah, yours as well. I'm sure there might be a couple of follow-up questions from intended parents that I might get emails around that. I'll send them all, maybe your contact details from here. I know there've been a couple of intended parents that have messaged that they might have an embryo transfer soon, so I'll be reaching out to you hopefully soon. Other than that, thank you so much for your time tonight. This has been really, really, really beneficial. And yeah, looking forward to the next steps in the process. So thanks again.
Great. Thank you. Thanks,
Take
Ed.
care.
Thanks, everyone.
Bye.